Judge Torres winks verdict in SEC case against XRP Ripple. U.S. Representative Brad Sherman recently advised the Securities and Exchange Commission, SEC, to go after crypto exchanges that supported Ripple's XRP token. However, in a recent interaction with Fox Business journalist Torres, Sherman made another claim against the token. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. After filing motions for summary trial, objections, and responses, the XRP community looks forward to U.S. Judge Analisa Torres ruling on the lawsuit to determine whether the crypto asset is a security. Although the XRP community hopes that Judge Torres will rule in Ripple's favor, some stakeholders believe that Ripple will lose the case. Gene Hoffman, Chief Operating Officer of Chia Network, is one of the cryptocurrency stakeholders who expect Ripple to lose the case against the Securities and Exchange Commission. In a recent tweet, Hoffman notified XRP holders that former SEC Corporate Finance Director William Hinman had informed Ripple executives that XRP was a security. He shared a screenshot of the SEC's claim in a recently filed response to a brief court ruling, urging XRP holders to prepare for the future after the loss of Ripple. Did you know that Bill Hinman told the management of Ripple that, in his opinion, XRP is a security in 2019? I don't either. Prepare for a future Ripple SEC loss. The founder of Crypto Law and the lawyer acting for Ripple, John Deaton, responded to Hoffman's statement, saying that he would put the comment in the proper context using facts. Deaton said that 2 months after Hinman's controversial speech in June 2018, when the former SEC executive declared ETH and BTC not securities, Ripple CEO Brad Garlinghouse and CTO David Schwartz met with former SEC Chairman Jay Clayton and Hinman to also get clear rules for XRP. He added that on June 13, 2018, the day before Hinman's controversial speech, SEC lawyers conducted a detailed analysis of XRP, applying the Howey test to determine whether the crypto asset is a security. According to Deaton's lawyer, if the SEC had been sure that XRP was a security, Clayton and Hinman would have informed Ripple executives at that meeting. However, Deaton claims that the agency never informed Garlinghouse and Schwartz that SEC enforcement lawyers considered XRP a security. This meeting between Clayton and Hinman with Garlinghouse and Schwartz was the perfect opportunity to tell Ripple that XRP is a security, assuming the SEC lawyers came to that conclusion. Deaton said that if the SEC had concluded that XRP was a security, the agency's enforcement division would have recommended filing a letter of enforcement action against Ripple. He added that the SEC would not sit idly by for more than a year after concluding that XRP is a security and watching Ripple executives sell illegal securities to the public. Deaton also says the SEC would have turned over the XRP memo at the time of discovery to give securities regulators an edge in the lawsuit. If the 2018 XRP memorandum had concluded that XRP was clearly a security, the SEC would have issued it for discovery, as was done in the minutes of the August 2018 meeting. If the conclusion on XRP designated it a security, the SEC would have handed it over and stated that Ripple has enough time to fix it. In addition, Deaton's lawyer said that in January 2019, Coinbase and its security lawyers met with Hinman about the exchange's intention to list XRP. Coinbase lawyers informed Hinman and the SEC that they ran XRP through the Coinbase framework to determine whether an asset meets the definition of a security. It is noteworthy that the SEC did not object to Coinbase, and on February 25, 2019, the exchange listed and promoted the widespread adoption of XRP. Ripple's general counsel Stuart Alderoty criticized the cryptocurrency-focused CoinDesk publication for his recent article about Ripple's lawsuit. CoinDesk columnist Preston Burns said in an article that he expects Ripple to lose the case against the SEC, sooner or later. Brim noted that Alderoty's argument is akin to denial. Ripple's general counsel claims that there was no investment contract when selling XRP because there was no formal contract between Ripple and XRP buyers, and that the tokens were sold for consumer use, said Brim. Reacting to a recent CoinDesk op-ed, Alderoty called on the media, which he called detractors, to understand Ripple's legal positions before refuting them. He noted that Ripple's brief response, filed on December 2, made it clear that the blockchain company does not rely on the conclusion that XRP was acquired for use. Although such a conclusion, as shown in the amici reports and not speculative evidence, contradicts the SEC requirements, he added. Alderati went even further to summarize Ripple's factual arguments in the ongoing lawsuit in 3 points. According to Ripple's chief lawyer, Ripple does not have an investment contract with any XRP holder. He said that the Securities and Exchange Commission cannot satisfy any of the points of the Howey test, adding that the Silicon Valley Technology Company is not inferior to any of the points of the Howey test. Alderati stated that Brim's claim that the SEC relies on multiple ICO cases matching all parts of the Howey test has no place in the ongoing lawsuit. In addition, Alderati said that the SEC and other detractors tried to change Ripple's legal position because they have no answers to the company's arguments. The reason the SEC and detractors try to recast our arguments is they have no answer for the arguments we actually make. Meanwhile, Alderati said he is pleased that CoinDesk also recognizes that an invitation from the SEC to crypto companies asking them to log in and register is not possible. I'm glad that even detractors recognize that inviting the SEC to come and register is like trying to send a Ford Model T into space, he said. According to James K. Phelan, Judge Torres can make one big written decision on unresolved issues of the trial, including petitions for summary trial based on precedents. Ripple General Counsel Stuart Alderati, who shared the news about the historic milestone reached in the lawsuit, believes that Ripple has fought well over the past 2 years. In December 2020, the SEC filed a lawsuit against Ripple and 2 of its executives, alleging that the $1.3 billion sale of XRP was an unregistered securities offering. Alderati mentioned that the summaries of the responses would mark Ripple's final submission in his bid for the court to rule in her favor. He says that Ripple is proud of the protection it has put up on behalf of the entire crypto industry, noting that the company has always played fair with the court. In a 62-page court document, the SEC argues that it is entitled to a summary judgment because the defendants did not object to the substantial fact that the XRP sales constitute an offer of an investment contract under Section 2(1) of the Securities Act of 1993. In addition, the SEC provided 3 facts proving that the Ripple XRP offer is an investment contract. According to the agency, Ripple and its executives did not dispute that the blockchain company received $2 billion from investors in exchange for XRP. In addition, the defendants also did not dispute the fact of establishing general entrepreneurship in the Howey test. The agency noted that the defendants' efforts linked the fortunes of XRP investors to each other, citing an excerpt from a memo by lawyer John Deaton Amici Curiae, which states that Ripple's loss will harm investors. In addition, the SEC argued that Ripple did not dispute another important aspect of Howey's test, the expectation of profit from the efforts of others. The defendants made an avalanche of public statements indicating that they would take steps to increase the value of XRP. Partly because of Ripple's giant pile of XRP, potential and actual investors realized that Ripple was financially forced to do just that, the agency said. According to the SEC, Ripple's opposite argument is that many XRP investors did not consider buying a crypto asset as an investment in a blockchain company. The U.S. Securities and Exchange Commission said that this argument does not comply with the law, since the main question should be whether Ripple has forced potential investors to expect profits from the efforts of others. The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.